Now, the ad hoc committee for the Public Protector's nominations wants South Africans to recommend candidates for the job. The cut-off date for nominations and applications is the 7th of July. And this call comes as the Section 194 inquiry into suspended Public Protector Busisiwe Mkhwebane's fitness to hold office continues. Mkhwebane is also expected to, quote-unquote, spill the beans on allegations of bribery and corruption involving members of the inquiry. Let's unpack all of this for you now. Bring in Lawson Naidoo, who is the Council for the Advancement of the South African Constitution, that's KSAC, joining us via our video link from Cape Town. Lawson, it's great to see you. Thanks as always for making time. And, you know, at this point, one hopes that great lessons have been learned about what we should avert if we are to prevent a repeat of Busisiwe Mkhwebane's tenure, at least all the bad that's come with it. I can't help but think about whether there's any way of making this an apolitical process as much as possible. We know ultimately the president decides who the Public Protector is, but how do we protect that person from being used, even just insofar as optics are concerned, as a weapon in political battles?
Good morning, and thank you very much for this. I think that is the critical question, and it was an issue that was raised 7 years ago in the aftermath of the previous process to appoint a Public Protector, is the lack of objective criteria for the position of Public Protector in South Africa. The Constitution and the Public Protector Act don't really provide us with sufficient criteria to determine what constitutes a fit and proper person to hold the office of Public Protector. There are some guidelines that are provided that the person must either be a judge of the High Court or a legal professional with at least 10 years experience or 10 years of experience in public administration, or as an amendment that was passed in 2002 provides, must have been a member of parliament for 10 years. And that was an amendment that was passed specifically to try and ensure that Lawrence Mushwana was able to get the job of Public Protector. But one of the issues that arose the last time when Makosi Khoza chaired the ad hoc committee in 2016 was to say that one of the recommendations from that committee was that Parliament needed to work to produce these objective criteria that would limit the amount of political interference. But ultimately, this is a parliamentary process. It therefore is a political one. But I think objective criteria would ensure that the right person is chosen for the position with the requisite skills, experience, and independence to be able to carry out the responsibilities.
Yeah.
I think what we've seen in recent times is a failure of Parliament to have implemented that criteria.
Sure. I mean, do you know what that objective criteria looks like? I mean, it's a pretty broad statement to be made, and I suppose one wonders, where would you begin?
Well, obviously one starts with the requisite qualifications, that the person should ideally have a legal background, should have operated at a very senior level. And I think this is alluded to in the Act when it speaks of 10 years of experience in a particular professional capacity. But this is an office that we know comes with great powers on behalf of ordinary people in the country, as was explained by Chief Justice Mkhwebane in the Nkandla case, where he spoke at length in that judgment about the importance of this office and how it is there to provide access to justice for people who would otherwise not be able to afford lawyers to go to court and redress injustice that has been inflicted upon them. So it comes with great responsibility, and therefore it needs to have someone who has the necessary integrity, respect, and stature to be able to exercise that great responsibility and hold organs of state to account where they have gone awry.
Yeah. Depending who you ask, many people might say that they didn't even know about this Chapter 9 institution before Chidi Madonsela's tenure, and of course everything that followed in the form of the state capture inquiry, because in part of her recommendations around the Nkandla issue. But from that point, I wonder what your reading of the current standing of the office currently is, given the last tenure we've had.
Well, I think the one thing we can say is that the office has a greater level of public awareness now in large part because of the tenure of the previous public protector, Advocate Madonsela, and because of the Section 194 inquiry that is currently proceeding in Parliament over the last couple of years, that there's a greater level of insight into the person that holds that office as well as the office at large. But we still tend to focus on the high-profile cases that are investigated by the Office of the Public Protector, and not what I would call, the real work of that office, which is to help ordinary South Africans, wherever that they may find themselves in the country, who are battling against maladministration or incompetence at the level of, service delivery or local government or government departments more broadly. So that's really where the impact of the office needs to be felt much more, because primarily it is an office that is there, as I said, to provide access to justice for those who would otherwise not be able to afford it.
Yeah. I wonder how deep down you reckon parliamentarians should dig in their probing of who is fit for this post. Sometimes we are privy to, interviews further afield where people are drilled even around their religious convictions. There's questions around where they stand on contentious issues like, abortion. And I suppose at the heart of that is to try to ascertain how they make sense of issues to do with morality and ethics, which aren't necessarily always written out clearly in law. Do you reckon we should go into that space, given the responsibilities you've just outlined of the Office of the Public Protector?
Well, I think we've got to start with the responsibilities of that office, and then design a set of objective criteria that is relevant and pertinent to the exercise of those powers and responsibilities. So, for example, in the last round of interviews in 2016, some candidates were asked about their views on the issue of the land question. Now, that's a very topical issue within South Africa, but one may ask the question of whether it's really relevant to someone holding the Office of Public Protector, who is required to determine whether there's maladministration in the public sector. So, the questions need to be pertinent, they need to be robust, they need to extract the correct information. But most importantly, the Parliament needs to provide itself with the objective criteria so that it can measure the candidates who come up before them against those criteria. And what we've seen in the past is really political horse trading, particularly when it comes to the shortlisting process, that there's no detailed examination of the candidates against a set of criteria. It's a bargaining process where a political party will say, I want these three candidates to be shortlisted. Party B will say, well, in that case, can I get these other two people there? And that's really how it was done the last time. That's an unsatisfactory way. And whilst we had a great deal of transparency in the process in 2016, and that is critical, that transparency needs to be coupled with a robustness of approach to identify the right person, because transparency in itself will not give us the kind of candidate that we require in order to raise the level and profile of this office and the effectiveness of the Office of the Public Protector over the next 7 years.
Yeah, it sounds to me that there are very clear pitfalls of this being a parliamentary process. If you were to have it your way, would you move this out of Parliament?
No, ultimately, Parliament must play its role. It is, it is the forum where our elected representatives sit, but they must sit there and understand the gravity of the task that they face, which is to appoint or to recommend a person for appointment as public protector, and discharge that responsibility seriously and with the gravitas that it deserves. So they need to take a step back and really say what is best for the country, and rather than taking a party political approach to the issue. And that's certainly not helpful in the case of the appointment of people to Chapter 9 institutions, as well as one may argue to other public offices in which Parliament is given a similar responsibility.
Lawson Naidoo, thanks for helping us think through these very different and complex issues. We'll be watching this process as it unfolds. But for now, thanks very much indeed for your time. Lawson Naidoo is with the Council for the Advancement of South Africa's Constitution. That's CASAC.